12th September 2019. Welcome to Salam Immigration. Today I am sharing with you some information about how a witness should give evidence in an immigration appeal. The immigration appeals are heard at the various immigration tribunals all over the UK. The tribunals are First Tier Tribunal and the Upper Tribunal. The appeals in detail and the witness evidence in detail are generally at the first stage, which is at the First Tier Tribunal. If you are a witness in a case, sometimes you may be the appellant as well as the witness in your own case. When you go to the tribunal, you should know how to give evidence apart from being well prepared and have knowledge of the issues. It is expected of the witness to know at least the important facts. Sometimes it happens the witnesses are not very well prepared and it looks like that they are not genuine witnesses or that they are just supporting someone with whatever they have been asked to say. So it is important that a witness statement in writing should say whatever the witness has to say on behalf of or for the benefit of the appellant. The tribunal requires that a witness statement for everyone appearing as a witness should be with them at least 5 working days before the hearing. Since the witness would have read his witness statement while preparing it, he should know whatever is in the witness statement and he should have read it thoroughly more than once before he goes to the tribunal. In entry clearance applications, the appellant himself is overseas, so he cannot give evidence in his own case. So most of the times it is a sponsor or a friend or someone who can give evidence on his behalf and to support his case. And sometimes there is a representative, a barrister, a solicitor or an immigration advisor, and sometimes there is no one except the sponsor, or sometimes it's the appellant himself and the witnesses. So the witnesses should be well prepared if there is no solicitor or barrister to guide them at the hearing. At the hearing, the witness, whatever he had to say is already the witness statement. So therefore the other side, that is the Home Office, have the right and the requirement to cross-examine that witness. Cross-examination means they will put questions to try to find out whether the witness is a credible witness, whatever he is saying is correct, whether he is a reliable person, whether his witness statement and whether his oral evidence are good enough for a judge to believe what is being said. So the witness should be very crisp and smart and should answer questions to the point. It should not look like he is trying to develop answers or think what he should say is most suited for the occasion, rather than saying the facts truly and plainly. The Home Office lawyer, who's called the presenting officer, would tend to put in questions to find out contradictions in the statement of the witness and also discrepancies between the statements or answers of one witness as against the answers given by another witness to similar questions. That damages the credibility of the witnesses, and then the court may rely more on the documentary evidence and less on the evidence of the witnesses. When the Home Office presenting officer would ask any questions, the witnesses should be only to the point, very brief. If the answer to a question is only yes or no, they should say that, rather than try to explain the case or argue the case, which annoys the judge. Sometimes the witness may not know something about what has been asked. If that is the case, plainly the witness should say, I don't know about that. Or sometimes if he cannot recall something, maybe he's been asked about something many years back, if he doesn't remember, he should not try to guess. He should simply say, I don't remember. There is nothing wrong with that. When questions are being asked, the witness has to say things to the judge. The question would be from the Home Office lawyer, but the answer should be given to the judge. And he should look towards the judge and see what the judge is doing. If the judge is taking notes, then he should slow down, take a pause, and see that the judge is able to take notes. Otherwise, whatever he has said, if it is not recorded, it will be useless. When the Home Office lawyer has completed his questions, then the other lawyer, the lawyer of the appellant, whether it's a barrister or whosoever, then he has a right to re-examine the witness, so that if there are some issues arising out of the questioning by the Home Office lawyer, he can deal with them by asking questions to clarify those matters. The judge would also ask questions of the witness in order to understand the case. The judge, when he asks a question, should be responded to in a little more detail, with the idea that the judge should understand what he is not current with, what he is not clear about. Sometimes the witnesses cannot speak or understand English very well. Even if they are good enough with their English, sometimes they don't feel very confident because of the technicalities or because of the court environment. So they do ask for an interpreter. So this has to be requested in advance. Your solicitor, or if you are acting on your own, should ask the tribunal, say 5-6 days at least before the hearing, that you need an interpreter. So the interpreter would be someone who knows your language as well as English. So he will translate everything, whatever is asked of the witness, into the witness's own native language, and then the answer in that language would be translated into English by the interpreter for the benefit of the judge and the two lawyers. When the cross-examination and re-examination is finished, then the witness doesn't have to say anything. He is not allowed to make a speech. Even if he is the appellant, he doesn't make a speech unless the judge asks him to make his submissions. The next stage would be the submissions. After evidence is completed, then the Home Office lawyer will make his submissions. He will make a speech and explain to the judge why the appeal should be dismissed. He will find out faults with everything, find out faults with the witnesses. He would try to find faults with the evidence and try to convince the judge that this case should be dismissed because it doesn't meet the rules and the human rights are not being breached if the person has been removed, or his application has been, or his human rights claim has been refused. While your barrister or representative or solicitor would argue to the judge, making his own speech, why the appeal should be allowed, how it meets the relevant provisions of the immigration rules, and how this will be a breach of his human rights if the appeal is dismissed, or if the person is refused or is removed from the country. So witness evidence is very important. It is a very key item of the whole process. Some of the assertions, some of the points that are relied upon do not find any place in the bundle or the papers. There is no documentary evidence for some of these points. So if documentary evidence is not available, that can be filled in by a statement from a witness who is cross-examined, and if everything looks fine, whatever he says, that becomes evidence. So it is very important that the witnesses give very good evidence. So go prepared when you go for giving a witness statement, whether it's your own case or it's someone else's case, and then you may expect a good result. Thank you very much.